At first, this almost sounds like a story of an elderly man whose addiction slowly took over his life. The defense is asking the court to focus on his health and limited time left, hoping compassion outweighs punishment. But in criminal sentencing, sympathy is only one piece of the puzzle. The judge also has to consider the danger the crime posed to the community.
Pussy ass motherfucker. I'm slapping the fuck out of your pussy ass this time.
Hey, who's using that kind of language?
Sorry,
Who was that?
Bobby.
Bobby, was that you doing that?
Yeah, I was cussing at myself.
You were saying you're calling yourself those names and you're gonna slap it yourself?
Yes.
I don't buy that. I don't buy that. Well, we need to wait a minute. Deputy, are you with him?
Yes, Your Honor.
Who was he talking about slapping?
The jailer, the night he set off the smoke alarm.
Well, it's not a good idea to threaten to commit a person crime as you're coming before the judge. Miss Gillette, Bobby Coe just joined us from the jail, and he was using MF and F words, threatening to slap someone who apparently is a jailer that was on duty when he allegedly set off a fire alarm. And that's why I was suggesting to him that that was not a good way to start the docket.
Well, I guess we'll get a copy of today's court hearing for Mr. Coe's new charges of criminal threat.
All right, Mr. Coe, let's take up your case. We're on the record in 2024 CR 170, State of Kansas versus Bobby Joe Coe, County Attorney Jill Gillette for the state, Defendant Bobby Coe.
This is where the case completely changes. The prosecutor isn't describing someone caught with drugs for personal use. He's describing someone accused of bringing large amounts of drugs into the community and supplying others. That's why the state pushes for a much harsher sentence, because the damage goes far beyond one individual.
Defendant Bobby Coe in person, in custody, and pro se. Mr. Coe, you're charged in one count. It's called, let me double check let me look at the official language. You're charged with unlawful request for emergency service assistance. The state is alleging that on or about the 12th day of September, 2024, in Greenwood County, state of Kansas, Bobby Joe Coe did then and there, contrary to the statutes of the state of Kansas, unlawfully and knowingly make a request for emergency fire assistance, knowing at the time of such request there is no reasonable ground for assistance. To wit, caused fire alarm to go off in jail, raising concern for jail staff. And this is a Class A non-person misdemeanor. If convicted, you could serve, in addition to whatever your sentence remains now on whatever charge you're serving, another 12 months and pay a fine up to $2,500. Who has your attorney been that most often that's been appointed?
William McLennan.
Okay. You don't have any more felonies pending?
No, ma'am, I do not.
He had Shannon Cooper on his misdemeanors before, and then she was the contract attorney, so he would need Mr. McClendon now.
He was the one. He was the one that I had for my city stuff, Jill.
What about his? What about our public defender contract with Richard Paw?
I don't know why there might be a conflict with Mr. Paw, but
okay.
Bobby,
is he out of the same office as Chris Pate?
Yes.
Yeah.
Chris Pate was my ex-wife's attorney on our child case.
Okay, all right, very good.
That's for CR 99, October 15th at 3:30. So he's already here in court on 3:30 with Mr. McClendon on 10:15. It's the case he's in custody on.
Wait a minute. Say that again, please.
He has a case October 15th.
One sentence from the judge stands out. He admits giving this defendant chances before. Instead of using those opportunities to change, the court believes the criminal activity became even more serious. This is often the turning point in sentencing. When rehabilitation no longer seems to be working, accountability becomes the priority.
October 15th, 2024 at 3:30 with Mr. McClendon as his attorney on the misdemeanor docket.
It's for what I'm sitting in jail on now.
I thought you were on a show cause right now. I thought you'd had your probation revoked. No?
No, ma'am.
No.
No,
He
it was driving while habitual. You sentenced me to 90 to 180 days.
He has a review of the time that you gave him.
Okay, so he is serving a sentence, but he's
Yeah.
set for review to see if he can get it modified. All right, and now he's got this charge of
This isn't
reporting a fire. Say that again, Ms. Gillette.
helping getting a modification.
Yeah, I know.
All right. So we will appoint William McClendon as your attorney, if he can take the case, and we will set this for October 15th at 3:30, at which time apparently you and Mr. McClendon have a motion for me to reconsider or to grant you parole for the case that you've been revoked on.
I haven't been revoked. It's just there
That
was
was
no
the original sentence, all right?
Yes.
Rephrase that. Now, let me rephrase that so we have a clear understanding. You are serving a sentence, and you and your attorney have filed a motion for me to consider letting you out early, reducing your sentence, paroling you, or something of that sort.
Yes, ma'am.
And now you've got this new charge, and then you came in here threatening to slap one of the deputies, and
Allegedly.
Allegedly, I heard that with my. You better not make me a witness in your
And
case.
this is the moment everything becomes real. Years of repeated offenses, previous convictions, and the scale of the drug trafficking all come together in one decision. A sentence of 16 to 40 years is enormous, especially for a 64-year-old defendant. Whether people agree with it or not, the judge makes it clear this punishment is based not only on this crime, but on a long pattern of similar behavior.
Be a witness in your case, Mr. Coe.
I apologize.
You're going to be in trouble.
I was just a little irritated. You know what I mean?
You kind of are a witness, Judge, because you saw it. So I'm going to have to order the tape of today.
Now, you ordered the tape and you called the deputy there, but if I have to come testify in your case, Mr. Coe, I'm not going to be very happy with you.
Well, I'll make sure that does not happen, ma'am.
All right, I don't know how you're going to do that, but
I don't either.
You and Mr. McClendon can work that out with Miss Gillette, but
All right.
anyway, we have to do what we have to do.
Yes, ma'am.
And I won't find you in contempt for talking like that in court, but you understand we don't.
Yes, I greatly apologize, and I hope that I do not get filed charges. I do not need any more trouble. I was a little irritated and aggravated.
All right. Anything further, Miss Gillette, on this matter?
No.
I apologize, Miss Gillette.
All right. Better apologize to that deputy. She didn't need to be hearing that either.
I apologize, Mayla.
All right. You can go at this time, Mr.
All right, thank you. You guys have a wonderful day.
Your Honor, do we have a bond on this case?
Yeah, do we have a?
Well, he's not going anywhere because I think he's serving a year, but
No, I'm serving 6 months.
oh, 6 months, excuse me. All right. But we can set one. I'm thinking 5,000 cash or surety. Let's make that his bond.
Okay.
Thank you, guys.
You're welcome.
Have a good day.